Hello, everybody. Thank you for joining us. This is a fantastic presentation. It is entitled Us Too, Bullying and Sexual Harassment in the Legal Profession, Findings and Recommendations from the Global Study. My name is Dayan Hockman V. Hill. I will be your moderator today, and it is my pleasure to introduce you to Kieran Pender, who works at the Legal Policy and Research Unit at the International Bar Association, who will be giving this presentation today. And with that, Kieran, I'll turn it over to you.
Thanks a lot, everyone, for joining on your lunch break if you're on the East Coast or whatever other time you're joining. And please do feel free to ask questions throughout, and we'll have plenty of time towards the end to have some questions. I wanted to begin with a few quotes that come from people who responded to the survey that underlies the report that I'll be talking to you about today. And the first is from a male lawyer in the US who said, "The partner with whom I worked was notorious for being profane and demeaning. He was relentless. He was proud that he treated people so badly. It was a badge of honor for him, and the law firm protected him." The second comes from a member of the judiciary, also in the US, who said, "I was repeatedly groped by a superior court judge when working as a young prosecutor and then as a private practice attorney. This went on for as long as the particular judge was on the bench. I developed strategies for avoiding most of the unwanted groping, backing up to a wall when seeing him in the hallway, avoiding him at social events, etc. It was not a situation that was ever reported." Now, as I said, these are just two of the thousands of stories that the International Bar Association was told when we undertook what would become the largest ever global survey on bullying and sexual harassment in the legal profession. And they're both very troubling stories, but they're certainly not unique. I'm sure everyone on this webinar and probably every member of the profession has either experienced bullying or sexual harassment themselves, or they have witnessed it, or they know of friends or colleagues who have. But the plural of anecdote, as I said in the IBA report, is not data. And so the IBA set out to undertake this research, to have the data, the empirical evidence on these issues. And just to set the context for that, it began really in 2016. We decided to undertake some research on the barriers that women face in the profession. So on the slide, we see there's been in the US, in the UK, and in Australia, and many other jurisdictions, gender parity at entry level in law school and entry level in law firms. I know, for example, this year, Georgetown, their first year JD cohort was 69% female. And I mean, that number has increased in recent years, but for 30 years or so, we've had at least 50% females entering the profession. And so the passage of time should have led to a situation like the pyramid we see on this slide, where there are most law firms would be clustered around 50% female partners, and then there'd be outliers on either side. Now, the research that we, the prior research that had been undertaken and just a scan of any major law firm website demonstrates that that's not the case. And so we set out to look at why the numbers were as they were, and we're not getting towards this more evenly balanced pyramid. And that report, which we published in 2017, Women in Commercial Legal Practice, it identified that diversity policies weren't working in firms, flexible working arrangements weren't working, discrimination, bullying, and sexual harassment were rife, and that men had a significant role to play in achieving this change. Now, my predecessor was undertaking this research in my role at the IBA, and she got these results in July of 2017, and she was working on this report, and it was being prepared to be published in November or December. And then on the 5th of October, the New York Times broke the Harvey Weinstein story, and what began as one individual story led to a global outcry and a global movement, being the Me Too movement. And the legal profession was not immune from that movement. And there were a number of high-profile cases in the US, in Australia, in the UK, and many other jurisdictions of senior lawyers, judges, in-house counsel being accused of these forms of conduct. And so, as I said, we had this empirical proof from this research, which we'd done before the Me Too movement had begun, and that had indicated it was a problem. But when the Me Too happened, that really said to us we needed to look at this in far more detail. And so those dual prompts were impetus for us. So there's the Weinstein slide. Were impetus for us to begin a new project, which we began at the beginning of 2018 on these issues particularly. And I should stress that I know bullying and sexual harassment are distinct forms, and we delineate them appropriately, but we believe they have a relevant connection. The survey we undertook, which in the end was completed by about 7,000 members of the profession from across the globe, about 135 countries participated. We had an overrepresentation of women responding. We also had an overrepresentation of law firm respondents, but we had still statistically significant samples from across the profession. We also had a fairly balanced survey sample in terms of age, with a slight grouping towards the younger end of the profession. I just want to very briefly talk about a couple of methodological points, because research is only as good as the underlying methodology. So I think it's important to be transparent about how we did this. So in the past, this sort of research has been done either with a self-labeling method, so that's applying bullying or sexual harassment to what you've experienced, or a behavioural method, which is listing sort of forms of behaviour and putting these labels to them and asking people if those experienced those indicative behaviours. And we combined the two. We began by saying, have you been bullied in your legal career? Have you been sexually harassed? And then we provided 10 examples for each, and we rotated them randomly so there was no ordering bias. It's important to note that for bullying on one hand, sexual harassment on the other, we weren't only looking to get legally actionable forms of conduct that had occurred. That's for a number of reasons. One, bullying in most instances is not against the law, whether civil or criminal. There's only very few countries that do have specific anti-bullying law. Similarly, a lot of sexual harassment, before it gives rise to serious inappropriate physical conduct or sexual assault, again, is not necessarily contrary to law. But none of this is acceptable in a profession, in any profession, but particularly our profession, predicated as it is on high ethical standards. And so we thought it was necessary to look across the whole spectrum, and also because past research had indicated that lower level forms of conduct were often, to use the words of the EEOC, a gateway drug to more severe forms of conduct. As I said, we're very transparent about the shortcomings of the research, and in our report, which is about 130 pages, makes for good bedtime reading, we talk in detail about the pros and cons of this particular research methodology. The two that I want to highlight, one is non-response bias. So if you're doing a survey on bullying and sexual harassment, there's perhaps a higher likelihood you may have experienced these forms of conduct, and that was a motivating factor in clicking the survey. We did a number of things to try and address that. Firstly, in all of our messaging on the survey, we highlighted the need that we wanted people across the spectrum of the profession to complete this, whether or not they'd been bullied or sexually harassed. And we also we matched this data with other forms of data, particularly, as I said, the prior piece of research we'd done hadn't specifically from the outset been looking at bullying and sexual harassment, so there was less risk of non-response bias in that context. And where appropriate, because this is an issue that disproportionately impacts women, and because we had an overrepresentation of female respondents, we gender weighted the results. So we're fairly confident with the findings, but again, we are very transparent about the pros and cons. The other challenge that we face with the data, I think, is neatly depicted by these two graphs with Russia, Australia, and Norway. Now, we hypothesized that the prevalence of these forms of conduct were roughly correlated to gender inequality, given their gendered dimension. And so we plotted Norway, Australia, and Russia representing 3 points on the UN Gender Inequality Index, Norway being very gender equal, Australia being about 20th in the world, Russia being about 50th. And there's two ways of reading these findings. One is that Australia has terrible legal workplaces and Norway and Russia are pretty reasonable. Or the other, as we hypothesize in the research, is that because these issues are so societal and cultural, and because in certain societies these issues aren't yet as prominent as they are in places like Australia, being my home country, or the United States, the United Kingdom, it may be that in countries where there's actually already efforts underway to address these issues, such as those just mentioned, the numbers are higher than they might be in some places where objectively perhaps the conduct is in workplaces is as bad, but efforts are not yet being undertaken to address them. And so we see, for example, the US has a very high rate of bullying and sexual harassment. I think I have a slide to that effect later on. We say of this, this is somewhat challenging for us as an international organization looking at this at a global level. This is a bit confusing to us. But the message we want to be the takeaway is it doesn't really matter. Whether you have 20%, 40%, 60% of your members of your profession in your country have been bullied or sexually harassed, that's 20, 40, 60% too many. So I just wanted to highlight these two methodological caveats because, again, I want to be transparent, but we are very confident of our research, its rigor, and we had it reviewed by 3 independent experts. So enough talk of methodology, which I hope I haven't put you to sleep. The findings are that the profession has a problem, to put it very bluntly. So these forms of conduct are rife, and no region of the globe and no workplace type, no particular subset of the profession is immune. The numbers are fairly consistent, although there is some variation, but reasonably consistent across all strands. So 1 in 2 female respondents, 1 in 3 male respondents have been bullied, and 1 in 3 female respondents, 1 in 14 male respondents have been sexually harassed. It would be nice if we could comfort ourselves with the idea this was a problem of the past. So if we could say, well, legal workplaces 20 years ago were really bad, but now they're better, and we don't have to worry about this anymore. That's not the case. We found that 1/3 of bullying cases and 1/4 of sexual harassment cases had occurred within the past year. And as I mentioned, there's a disproportionate impact on American lawyers compared to the global average. So for both sexual harassment and bullying, lawyers in the US, similarly to Australia, similarly to the UK and a few other jurisdictions, had significantly higher rates, which I think is troubling. Again, there's that paradox question which may be at play here. I also think it's important to stress it's easy to become desensitized to these numbers. And as someone who works with this data every day, perhaps I have become somewhat desensitized. But they are really shocking, and I don't think we should try and detract from that shock. That 1 in 2, more than 1 in 2 female lawyers in the US, according to this research, has been bullied and sexually harassed, and almost 1 in 2 male lawyers have been bullied, and 1 in 10 male lawyers sexually harassed. That's not okay. In no world is that okay. And I think it's really incumbent upon us to use this data, and as I'll talk about towards the end, what we're actually going to do about this, it's incumbent upon us not to forget that these represent real people. And again, it's easy to use numbers to with numbers, it's easy to forget that these are very real incidents and perhaps this is only something that afflicts me because I look at this every day at a macro level. And that's why I think some of the stories we've been told and in our report we try and use and we scatter these stories throughout the report to make that impact that these are forms of conduct we urgently need to address, because this is simply unacceptable in any profession, but particularly in our profession. The impact, one reason we're so keen to collaborate with the ABA Young Lawyers Division is that the impact on young lawyers is disproportionate. So that's on the chart, bullying within the past year, and you can see it's fairly obvious disproportionate impact on younger members of the profession. And the statistics and the graph for sexual harassment is fairly similar. And so if we look at, we ask people about all the bullying they'd experienced throughout their career, and if there was no correlation with age, we'd expect to see an upwards linear progression, and we don't. So lots of evidence that age has an impact. And I think that should concern all of us, and particularly senior leaders of the profession, because younger members of the profession are the future of the profession. And if they are being bullied and sexually harassed, and as our research shows, are leaving as a result, that is a significant threat to the long-term viability of the profession. We found that bullies were predominantly the supervisor of the respondent or someone else of seniority, and most of the bullying that had occurred was supervision related. I think that poses a challenge because the line between management and bullying is not crystal clear. You know, the line between general interaction and sexual harassment is very clear, but with bullying it's a bit more murky, and what to some person might just be a challenging boss is to someone else a bully. We say in the report, where the line is drawn is, again, almost irrelevant. That so many members of the profession say they're not happy with the way they're being supervised, that's a problem, whether or not you put the label bully on it or not. And bullying overwhelmingly occurs in the physical workplace, so this is happening at work. Sexual harassment, on the other hand, the power imbalance aspect is still there, but it's not as noticeable. So supervisors were less frequent perpetrators relative to bullying. The most frequent perpetrator was a non-supervisory senior colleague, and relative to bullying, colleagues, peers, and even junior colleagues were more likely to be perpetrators. And relative to bullying, again, sexual harassment happens less in the physical workplace and more at social events, conferences, work travel, etc. For a lot of these data points and findings, they're either fairly obvious or something we already knew anecdotally, but our view is the data is significant because it gives us a very clear picture and a platform through which to try and advocate for change, but B, it provides incontrovertible evidence of the way these forms of conduct manifest, and it makes it clear, and it removes the criticism of, as I said, the plural of anecdote is not data. So the profession has a problem, and that problem is exacerbated because people do not report. So when I talk to people about these findings, some people seem to have their eyes closed and are very troubled to hear of this and say, oh, I had no idea that this was such a problem. And one reason some people have no idea is because these forms of conduct are just simply not reported, and so therefore people don't know. And the reasons that are cited for not reporting, again, fairly self-explanatory: fear of the perpetrator and their his or her or their status, risk of reprisal, and that these issues are endemic in the particular workplace. In the rare cases where people do report, targets, victims do not report to us that they were satisfied or happy with the outcome of the workplace's response. In just a quarter of cases was the perpetrator sanctioned, which indicates that concerns about a lack of appropriate response are probably very well founded. The most common workplace response to dealing with these issues at a preventative and at a responsive level are policies or training. And we found that workplaces don't have enough policies. So only about 1 in 2 legal workplaces had policies to address these forms of conduct. and only 1 in 5 undertook training. Now, those numbers in the US are slightly higher. I suspect that reflects certain regulatory differences in the US compared to other jurisdictions. But even in the US, until every workplace has policies in place and undertakes training, not enough are. Given that this webinar is arranged with the Young Lawyers Division, I wanted to highlight this figure, which indicates that prevalence of policies varies by age. Now, whether a workplace has a policy or not is an objective fact, and so shouldn't vary by age, and the percentages here should be identical. That they're not suggests one of two things, and they can both be valid. One, that younger members of the profession are not doing enough to inform themselves of the existence and the policies and procedures that are in place. And secondly, that workplaces aren't doing enough to bring these things to their attention. And I suspect, and the report hypothesizes, a very good explanation for this divergence is that the older you get in the profession, given the correlation between, relatively strong correlation between age and seniority, you are more likely to have a managerial role, and therefore you're more likely to come across these things by virtue of that role. So we suggest that the profession needs to do much more, making sure younger members of the profession are aware. So, for those listening, if you're not already aware, I'd encourage you to go and find out what your workplace has in place in this regard. As I said at the beginning, regardless of the impact, these forms of conduct are not okay in any profession, and particularly one such as ours that prides itself on high ethical standards. And so for that reason alone, that ethical and moral impetus, for the legal impetus that often these forms of conduct are against different laws, we should want to stamp this out. But the report identifies a very compelling business case as well. It feels a bit dirty using those words in this context, but the clear message of the research is that the impact of this conduct on the profession as a whole is substantial. So not only does being bullied or sexually harassed have a significant personal impact, professional, potentially financial impact, but it also has a serious impact on the target. Not only on the target, but also on colleagues. It's not nice to work in a workplace where your colleagues are being bullied, and the profession as a whole. So we found that significant numbers were leaving either their individual workplace and in some cases the profession as a whole because they're enduring these forms of conduct. And I think that should be immensely troubling to all of us. We had an event in Edinburgh recently, and the managing partner of one of the biggest firms in Scotland was on our panel talking about these issues. And he relayed a story about when he was starting as a lawyer, he was training at his firm. For the first 3 months, he was bullied every day. And he would go home and cross off on a calendar the days until he could quit. And fortuitously, for unrelated reasons, the partner that was bullying him left after those 3 months. And this person went on to become the managing partner of that firm 20 or so years later. And on one hand, I was very uplifted by that story because this guy had showed resilience and got through it and managed to go on and become the managing partner. But then I reflected, for every nice story like that, think of how many people have left their workplace or the profession as a whole because they've been bullied or harassed. Think of the managing partners, the star lawyers, the general counsel, the government lawyers, the in-house counsel, that we are missing out on as a profession and as an individual workplace because they have left. They've said, no, this is not for me and I'm going to go elsewhere. I think that should concern all of us, and really it should concern society as a whole. And the impact is disproportionate on young lawyers. Just pulled two comments from the report that bear that out. As I said, it's disproportionate on young lawyers, both in terms of prevalence, but also in terms of the impact it then has. And that is, again, not entirely surprising. Before I move to the next section, I want to, I think I'm concluding on this slide, which is we asked at the end of the survey, putting aside individual incidents, putting aside everything else, generally, what do you think of how your workplace responds? So whether you've been bullied or not, Is your workplace doing a good job addressing these issues, both preventing and responding? And we see from this figure on the screen that even in the best performing workplaces, being law firms, only 1/3 of the profession thought that their firm was doing a good or excellent job. And so I think that shows that we just have so much work to do. And I'm sure these numbers are not unique to this profession. I'm sure lots of other workplaces have these same challenges. But as our report says, that's not the point. We have to get our own house in order, particularly because it's often lawyers who are advising other places, other workplaces, on how they should get their house in order. So as the president of the International Bar Association said in the foreword to this report, if we don't have our own house in order, are we any better than hypocrites? And just before I move to the next section, a few more quotes from the survey. A Swedish lawyer, at an office party, a female lawyer was intoxicated and approached me, touching me in a sensual way and suggesting that we go home together. I repeatedly told her no. She ignored this and put her hand on my crutch. This quote goes on, I must have cut it, but this quote goes on to reflect on the fact that if it wasn't for the Me Too movement, this particular lawyer would never have reflected on that incident as an example of sexual harassment. And I think the report indicates that sexual harassment of men is a problem, and it's a very unconsidered problem for several reasons, one of which being that there's a societal expectation that these things don't happen to men. Men can't be sexually harassed. There was one quote from someone, a male who'd been sexually harassed, who said, "Who believes that a man doesn't want to have sex?" I think this is a real problem. And another from a female lawyer demonstrating the impact of these issues. I was systematically bullied to the extent I considered for the first time of taking my life. My confidence was shattered. I began to doubt myself in every aspect of my life, work and personal. The advice I received from the Law Society was appalling. It was just get on with it. I'm going to take a 1-minute break and close the window, which I thought I had closed, so the tram noise stops. So everyone can get a glass of water, and then we'll continue with the next part.
Hi, everyone. This is Jay Hockman Hill. I'm just going to interject for a moment. It does appear that we have some questions that are posted, but I just wanted to let everyone know that we are going to be reserving questions until the end after the presentation has been finished. Thank you.
My apologies for that. We'll just briefly talk about what next, which I think is very important, and then we'd love to hear from you, whether your questions or thoughts. The report sets out 10 recommendations for how we as a profession address these issues. The data is only a starting point. The report, we hope, will be a vehicle to achieve change. Now, we are realists. We realize that change takes time, but we really hope this is the moment the profession can look at this data, which, as I said, is global, crosses all of the sectors of the profession, and says, this is a problem, we need to address it. And so we set out these 10 recommendations in quite detail. I'll obviously only be summarizing just a few of them now, but I would encourage you all to download the report or the summary that's available online and look in more detail. And for each recommendation, the IBA has set out things that we will do, and we want to walk the walk on this, not just talk the talk. And so the first recommendation is that we need to have this discussion, and so that's why I'm joining you today. That's why over the next 6 months, it was started last month, in fact, we're having events across about 20 cities in 6 continents. We started in London, Edinburgh, Budapest, Mexico City, New York, DC, and so on and so forth across the globe, continuing this dialogue that in some places is already happening, and in some jurisdictions this dialogue isn't happening, and we want to spur it there because, as I said, we found this is a global problem and no place is immune. We believe bar associations, law societies, regulators, other stakeholders should be talking about this as well, and workplaces need to be doing more to discuss this on the basis that we need to break the silence on this. We need to break the taboo. We need to make it clear that this is a problem, and only by shining that light on it can we hope to move forward and achieve positive and meaningful change. And there's a map of some of the places we're going or have been. My carbon footprint this year is going to be horrendous, and for that I apologise to the climate profoundly. Pick up on the findings about policies and training. We need workplaces that have policies and standards in place to revise them and ensure that they are effective and in line with best practice. Those that don't have policies in place need to be doing that. And organisations such as bar associations, law societies, regulators should be taking steps as well to be making sure they are articulating clear and coherent standards and codes and regulations on these issues. Training is not happening enough. It should be happening more. And it needs to be regular and customized. Our research and other researchers found that off-the-shelf training packages don't work. Now, I think some people have suggested to me that these are all very well and good for large law firms with significant resources, but if you're a small firm, you might not necessarily have the resources to provide regular and customized training. I am sympathetic to that to a degree, and the report suggests that bar associations and law societies have an important role there in assisting the profession and providing training as CLE or CPD, for example, providing best practice policies and standards. But I also think no matter what your workplace size, having a workplace that is free of bullying and sexual harassment, A, it should be a minimum standard. B, you should want it because the negative impact of bullying and harassment is significant. And therefore, the cost of implementing these things is a cost of doing business that should be entirely acceptable in light of the importance of addressing these issues. We all need to take ownership of this problem. We are fortunate at the IBA that this is an issue that's been championed right from the very top. That's a photo on the slide there of our president launching this report at an event in London. But all of us, from those who've just started their law degree to those who are managing partners of international law firms, we all have a role to play in addressing this and working towards a better legal profession. But particularly those at the top need to take this seriously and indicate and take steps to ensure these issues are addressed. One of the greatest challenges that is faced in this area is how we empower people to report rather than silencing them, as currently happens. And there's no easy answer to that. Even having spent 16 months of my life doing this research and now subsequently working on the engagement and promotion, if I was bullied or sexually harassed, I don't know whether I would report. I am entirely sympathetic and appreciative of the many barriers there are to reporting. And so workplaces need to take steps to remove those barriers. And there are different models. The report talks about various ideas that have been floated in different jurisdictions as to how that happens. But it needs to start with clear messages from the top that reporting is not only accepted but encouraged, clear position of non-retaliation, a flexible model that doesn't try and funnel people just to one channel, and a consultative process that isn't simply enforced upon people. As I said, this is the challenge. If we get more people reporting these incidents, there'll be more awareness, workplaces will be forced to take action. We will move towards better legal workplaces. But finding ways to encourage people to report is hard because of the manifold barriers that prevent reporting. These forms of conduct don't occur in a vacuum and are tied very closely to other issues: mental health, workplace satisfaction, diversity and inclusion. And for all of them, there's a very bi-directional relationship. So diversity, as we found in our prior research, these forms of conduct are barriers to diversity. But similarly, if we had a more diverse and inclusive profession, we would almost certainly have less bullying and sexual harassment. So I guess there's a bit of a chicken and egg question, but that relationship needs to be appreciated, and these issues need to be addressed in a holistic and integrated way, so that we can work together to achieve all of these targets. One where mental health is more understood and valued and well-being is promoted, one where there's more workplace satisfaction, and one where we have a diverse and inclusive profession. And finally, and again, very challengingly, we can't let the momentum that's been generated by the Me Too movement fade. And I certainly don't want a colleague of mine in 20 years' time to be writing Us Too, as the report is titled, Volume 2. Now, that may sound hyperbolic, but the profession has had Me Too movements in the past. The Weinstein incident and the scandal and the subsequent movement that sparked from that, we've had similar incidents. The report begins in 1983 when a US law firm wanted to hold a wet t-shirt competition for its female summer associates. And some colleagues of those who wanted to hold this competition said that's not a good idea. And the people who wanted to hold it said, okay, well, rather than having a wet t-shirt competition, we'll have a swimsuit competition instead. And the person who won the competition, who was a Harvard law graduate, a partner, so she was offered a graduate job, and a partner said to the Wall Street Journal, no less, of her, she has the body we'd like to see more of. You know, understandably, that caused huge outcry in the profession at the time. Fast forward 10 years, there was a significant award of damages in a sexual harassment lawsuit filed by a secretary against a partner at a major international law firm in San Francisco. Around a similar time, the American Bar Association actually passed a formal resolution saying that this is a problem that we need to address. In the late 1990s, there was an incident in a strip club. A lawyer in London was told to go to a strip club with a client. On each of these occasions, we've had mini Me Too's, and there's been discussion and outcry and commitment to do better. And yet here we are. Now, I think that we have changed from 1983. I suspect no law firm would be stupid enough today to have a swimsuit competition. But as this research shows, these issues are still rife. And so we can't let the momentum that's been very fortunately generated by a very unfortunate set of circumstances go to waste. We really need to maintain the momentum on this issue and achieve positive change. Because any incident of bullying or sexual harassment in this profession is an incident too many. And as this research shows, these issues are sadly pandemic, and we must act together and urgently to address them. And I think this quote from a lawyer from the UAE in 2 sentences really encapsulates what took me about 35,000 words to say in the report. I've joked to my boss that we should have got this lawyer to write the report instead. There should be no place in this profession or any other for bullies or sexual harassers. At the very least, people deserve dignity and a safe, supportive environment in return for their work. Before I take any questions or we have any discussion, I just wanted to say that firstly, change starts with us. You know, no one, I would hope, listening to this or when I talk about these issues to rooms, no one thinks they're a bully or a sexual harasser. I certainly hope not. I hope that I'm not a bully or a sexual harasser. But we should reflect on our own conduct and whether we might inadvertently be acting this way, whether we might be facilitating or exacerbating it occurring, being committed by other people. Are we inadvertently empowering others to act in a bullying manner? When we had an event in New York, at the end of the evening, the executive director of the New York City Bar Association said, you know, everyone in the room, in a way, we're preaching to the converted. I mean, you've joined this webinar, obviously you're interested in these issues. That suggests that you're already sort of on board. But there are many people out there who aren't. And so his challenge to everyone, and I would raise the same challenge to all of you today, you know, use this report and this presentation as a tool to talk about this. You know, go back to your office, talk to one other person about this, someone who who you feel comfortable talking about this with them, that won't think that you're accusing them by bringing it up, but who maybe needs to think about this in more detail. And I think we need to be critical and reflective on the role that young lawyers and groups such as the YLD have in promoting this change. I was having a very interesting discussion recently with the global head of diversity and inclusion at Clifford Chance in London. He was the man who spearheaded the marriage equality campaign in both Ireland and in Australia before recently joining Clifford Chance. And him and I were discussing that the challenge that young lawyers and young people, the challenge he had in those campaigns were that young people, of which I consider myself one, we're on board with all this. We're not tolerant of workplaces where these issues are rife. In the instance of marriage equality, the demographic data from both Ireland and Australia showed that there was overwhelming support for marriage equality from those jurisdictions. Hello, I think I've just dropped out.
I'm here. Can you hear me, Kieran?
Sorry, I just dropped out briefly. Yes. Sorry about that. I'm not sure what happened. The long story short is young lawyers, young members of the profession, we're on board with this push, but we don't necessarily Sorry, my internet seems to be suddenly, for some reason, dropping out. Maybe I'll end on that note. Sorry if you didn't all get that note, by saying that, obviously I'm speaking to presumably a predominantly American audience. The flyer and the report are available in English. It's also available at the moment in 8 other languages, and we're hoping to have it available in more. So spread the word. Please be champions for this research. Because all of us will benefit from a profession that has less bullying and sexual harassment. Thank you very much for your time, and I'd be delighted to answer any questions.
Okay, great. Thank you so very much for a very informative presentation, Kieran. We really appreciate it. At this moment, we're going to go to some questions that have been asked by the audience. Now, keep in mind, Kieran, I think that some of these questions were asked in context, and so hopefully you'll be able to intuit at which point during the presentation the question was asked, and if not, perhaps we can ask that person who did ask the question to give us more information if we need it. So the first question is, what is the best way to go about it? I assume they mean reporting any sort of sexual harassment. Do we warn our attacker, or do we just report it to the ABA?
I think, this will be fairly circumstance dependent, and I wouldn't want to sort of cast definitive judgment. Reporting internally to your workplace is not normally going to be the best way to go. I think bystanders have a really important role to play that has been underappreciated until now. We shouldn't leave all of the burden on people who experience these conduct. If we see things, we should call it out as it happens. If someone says something that's not appropriate, rather than leaving it the burden on the person it was directed to, we should all of us say that wasn't okay. Now, that's going to be challenging if it was the managing partner of a law firm or the general counsel of an in-house or government legal workplace. But we all together need to achieve change, and that starts by just calling things out. If you don't feel comfortable in your workplace, if it's a serious nature, reporting it to the regulator is certainly an option. These forms of conduct, if they are on the more serious scale of severity, are often in breach of lawyers' ethical obligations and their regulatory obligations.
Okay, great. Thank you. Next question is, could you discuss in greater detail what makes a bullying/sexual harassment policy more effective? I'm particularly interested in the context of a mid-sized law firm. Thank you.
Sure. Quite a lot of research has been done on what makes an effective policy or training program, and the report discusses that research in quite some depth. So I'd encourage the questioner to look at that. One of the challenges, though, is that doing this sort of research is, it doesn't occur. It occurs in a somewhat artificial environment until, it's very difficult to see how something works in the wild, so to speak, in a workplace. Things that have been identified as being important are, the fact that it's regular. If you've got a policy, you're telling your staff about it regularly. It doesn't just sit on the shelf. The message has to come from the top and be consistent. So senior members of the firm, the managing partner, senior partners need to be saying on a regular basis, we take this issue seriously. We will not tolerate this. If we find out this conduct is going on, we will take appropriate steps. So to that end, it should be tailored to the individual workplace. In terms of training, we interestingly, we asked people, do you have training, and if so, who did it, whether it was internal or external or both. And interestingly, external training had a very low efficiency. We then asked people, did you think it was adequate? And training that was only done externally wasn't viewed as adequate, whereas training that had a mix of internal and external had the highest adequacy rating. I think that suggests that it emphasizes the need for these things to be customized. It's all well and good having an external specialist come in, and I think there is benefit to that if resources permit, but it needs to be tailored to the right workplace. There's no point giving a sort of big picture on this if it's not relevant, and people just will tune out and won't listen. So as I said, that's a very short summary, but there is a lot, and the report goes into a lot of detail about some small steps that can be done to make policies and training better.
Okay, thanks. So our next question is going to be, is it helpful to respond to the financial impact of training with a financial counter argument, specifically that safer and supportive work environments are more productive and bring in more money in the long term? Or is it more, or does it, sorry, I'm gonna have to rephrase this here, or is more good done to focus on the moral and philosophical reasons you identified?
I think that will depend largely on the person that you're trying to persuade. But I think, I would probably begin with the moral, ethical, and in some cases legal obligations. So in some jurisdictions, obviously it would vary by state. In the US, there are particular obligations for places to run training and have policies. But if that isn't persuasive, then the financial element is inarguable. And I think we're beginning to see more and more law firms. There have been some cases at big international law firms where they've had rainmaking partners who bring in millions and millions of dollars every year, and incidents have arisen, and the firms have terminated the partners. That in the past was very rare. We're beginning to see more of it because I think firms are realizing that the reputational impact of allowing these things to go on and the financial impact of, sure, that one partner might bring in money, but if they're making 10 people's lives miserable and they're leaving or they're unhappy, they're not productive, that's a significant financial hit. So I think, both arguments carry weight.
Okay, next question. How about with people with with a power imbalance like judges?
Yeah, I think that's a real challenge. I think judicial bullying is a particular and certainly complex subset. I know, I can't speak as to the US experience, but in Australia, in the UK, judicial bullying of lawyers before them is a really hot topic at the moment, and bar associations and law societies are trying to take steps to engage in dialogue with the bench. To point out that these things aren't okay. In any of these cases of power imbalance, that's a challenge. I think one reason why flexible reporting models are attractive is if they provide a number of different touch points. So, if you're not comfortable reporting to someone in your team because your supervising partner is the bully and he or she has a lot of dominance in the team, being able to report to someone else, a partner in another team or HR or just having a lot of touch points empowers people. It makes it a lot less challenging to raise these issues. And for example, in Victoria, in my home country of Australia, the bar there, they have a bifurcated profession with specialist barristers, and they've created a 3-tier reporting model so that if you don't want to raise it you don't want to name someone, you just want to tell someone that something's happened, again, in an anonymized way, you can do that. And that's known to the leaders of the profession, but entirely anonymized. If you want to raise it, but in a non-investigative regulatory form, you can do that, and the bar tries to conciliate if possible, but it doesn't necessarily lead to disciplinary action, or you can go that third route. So again, just having multi-layered systems that you can just do what you're comfortable doing. I've had a lot of people responded to the survey saying this was the first time they had told anyone what had happened to them. Now, that is, I think, troubling that people don't feel more confident sharing it in to colleagues, to appropriate authorities. But if all they feel comfortable doing is reporting it anonymously, then that's a useful starting point.
Okay, next question. Where do we go to report?
I think I've somewhat answered that. Internally, I think would always be preferable, and then it would depend somewhat on where you are, your state or region. But in some instances, local bar associations and law societies or regulators have a function to play there. And if you're in government, often there's sort of external third-party ombudsmen as well, ombuds people that you can approach.
Okay. I would also like to get this presentation if possible. That is beyond my wheelhouse. Kieran, are you in a position to be able to send out the presentation, or will this be available? Well, I imagine this will be available on the ABA website after this session.
Of course, more than happy. I've provided it already to the ABA so they can take whatever steps they wish to spread it to the world. But please share it and make use of it. And this is all, not the presentation, but the full report, which has many of these graphics, the 4-page summary flyer, infographic in these different languages. They're all available on the IBA website, which is I'm having a mind blank and I can't remember the web address, which my colleagues would give me a hard time about. But yeah, if you Google IBA harassment, you'll come up there. It's all there. We've got videos of the president of the IBA talking about these issues. You've got videos from the different events we've had. We try to compile a lot of different research and resources to make it a hub for these issues to empower the profession to move forward and address them.
Okay, Kieran, I also believe you may have addressed this question, but if anybody is interested in getting the full report, could they go to the IBA website as well?
Yes, it's available to anyone. You don't have to be an IBA member. It's free. It's downloadable. Please read it. I think maybe if I have on the next slide, I have my email address. Send me an email if you have any thoughts. We'd love to hear them. The IBA has made this a high priority, and we're really keen to work with the profession as a whole in all different ways to address these issues. So please feel free to get in touch.
Okay, great. That concludes all the questions that we have. At this time, I'm gonna, maybe we should wait a couple of seconds here to see if any other questions come in. Well, it doesn't look like we're getting anything else at this time. So Kieran, I wanted to thank you for a fantastic presentation. I know that I learned a lot from this, and thank you also for the important work that you're doing on this subject. And thanks to every single person that joined us today to be able to take part in this presentation as well. At this point, I think we're going to conclude the webinar, and thanks all who joined us. Have a good day.
Thanks a lot.